Hello everyone. Myself Dr. Zubair Ahmed, working as Assistant Professor, Department of Law, Alia University, Kolkata. Today we are going to discuss about our module, Offences Affecting Against the Human Body. In this module, we are going to discuss about few of the offences that are categorized into Indian Penal Code 1860. The Indian Penal Code 1860 is a criminal code which is enforced in India throughout the territory of India, which recognizes offenses committed against different types of aspects. And today we are discussing about the aspect of offense committed against human body. In this regard, in this particular module, we are going to have an elusive understanding of 9 various types of offenses that are categorized under the Indian Penal Code, like as hurt, grievous hurt, wrongful restraint, wrongful confinement, criminal force, assault, kidnapping, abduction, and slavery and forced labor. So we will start our discussion with the concept of hurt. Hurt is prescribed or discussed under section 319 of Indian Penal Code, which says that if a person causes bodily pain, disease, or any type of infirmity to anyone by an intentional act, then it will result to commission of the hurt. The offense of hurt, though it is a minor offense, so it is a compoundable offense. That is, a person who has been aggrieved by another person, he can pardon the offense if the person thinks fit. In cases of hurts, there is a prescribed punishment is provided if any person intentionally commits the offenses of hurts in this regard to any individual. The punishment provided is an imprisonment up to 1 year or a fine which may be up to 1,000 rupees or a combination of both. The offense in this category is looked upon as a non-cognizable offense and it's a bailable offense. The second offense in this category which we will discuss is the concept of grievous hurt. A grievous hurt is an aggravated form of hurt. That is something more than the hurt. In case of grievous hurt, the Indian Penal Code under section 320 prescribes 8 different categories of things which may constitute grievous hurt. Among these 8 different things, we start with the concept of emasculation. That is causing grievous hurt by emasculation, that is castration of the male organ. The sexual organ of the male, if it is castrated, that is cut off, then it amounts to a grievous hurt under section 320 of Indian Penal Code. Secondly, permanent privation of either eye of an individual. Permanent privation means whenever an act is committed by which an individual's eyesight is affected in a way that permanently the person will not be able to use the eye for sighting anything. Maybe by use of a sharp weapon or any chemicals or in any way, if this permanent sight of an individual is affected, we may say that it is permanent privation of the eyesight. Thirdly, permanent privation of the ear, any of the ear. So that is hearing capacity of the ear if is affected by an act of the individuals by use of any weapon or any other chemicals or any individual things which causes such person to permanently impaired, that is not able to hear by using any of the ear, then it will also amounts to causing of hurt. Another thing which is considered in this, that an privation of the joint or member of the body. That means that whenever an act is committed against a person in a way that any joint or a body part is not able to do its function properly, then such active will amount to commission of a grievous hurt. For example, shoulder, knee, ankle, such are the joints of the human individuals. If these joints are affected in a way or it are being force is used in a way that the person is unable to do or there is a rupture in those organs, then it will amount to grievous hurt. Destruction or permanent impairing of any of the members or joint. Permanently, if such joint of the body is unable to do its function. For example, a person is heated in a way that the knee of that individual has broken. So these knee balls are not able to perform, so now the person has to use certain supports for walking. Similarly, if any way a person is heated, that a person's elbow is heated in a way that the person permanently loses the capacity of these elbows, then it amounts to grievous hurt. Disfiguration of the face. Disfiguration means whenever an act is done whereby the look of the face will be affected. In case of disfiguration, any particular element or any particular conduct is done by an individual whereby the face outer look get disfigured. So the function of the face, that is any other in physical functions of the face, it will remain as it is. It is not affecting the functionability of the face. Rather, its look will be affected by an act of individual. Fracturing of bones or teeth. A fracturing of bones or teeth means that dislocation of bones or teeth. Dislocation of teeth means any act by which a person's teeth is dislocated. That is, if somebody make a blow in the mouth so that the tooth has dislocated, it amounts to grievous hurt. Similarly, fracture of the bones means whenever an act is conducted on the individual such that the person's bone is not able to do day-to-day function. It may be broken or it may be a fractured way. So in both conditions, it has been held that this will amount to grievous hurt. And lastly, any bodily pain which is inflicted upon the person so that the person is in pain for 20 days, so that for 20 days the person is unable to conduct its day-to-day life activities. That is the common activities that a person may conduct in day-to-day life. He needs support or she needs supports to do daily activities, then it will amount to causation of grievous hurt. Punishment of grievous hurt is provided under section 325 of Indian Penal Code. Section 325 says that and punishment for an conduct of grievous hurt may be up to 7 years imprisonment. So a person who has inflicted grievous hurt upon another individual may be imprisoned for a term of 7 years in this regard. Next, we are going to discuss is the wrongful restraint. Wrongful restraint is discussed under section 339 of the Indian Penal Code. Wrongful restraint amounts to an offense when any individual is stopped from proceeding in a way where he have got right to proceed. In case of wrongful restraint, what happens? That certain individuals are having rights. We know that every individual is having right to move in any particular way subject to certain laws. So if we are having a right to proceed in a direction and somebody obstruct to move in the direction, we can say that wrongful restraint is committed. There are certain essentials which are required to be fulfilled in case of wrongful restraint. Purposefully and voluntarily obstruction. The person who is obstructing, it must be done purposefully. That is, intention is a very important content in case of wrongful restraint. So individual who is obstructing must have an intention to obstruct the other person in proceeding in a direction in which the person is having right to proceed. When we say right to proceed, it means that he is not withheld by any law to proceed. For example, if we are having an army base or military camp which has been made in a particular area and a person as an individual public want to go proceed in that direction, he doesn't have or she doesn't have right to proceed in this direction because it is restricted area. So this direction to proceed means a normal right having to move in a particular direction and it has been stopped or curtailed by an individual unlawfully, then we can say wrongful restraint is committed. In case of wrongful restraint, a person may be imprisoned with 1 month as well as a fine of up to rupees 500 can be prescribed for that causing of wrongful restraint. Next section, next provision is the concept of wrongful confinement. A wrongful confinement is the next stage of wrongful restraint, or we can say that is the next step of commission of crime where a person's movement in every direction is being curtailed. In case of wrongful confinement, there is necessity that the movement of the person in circumscribed limit is prohibited. That is 4 walls or 4 boundaries in any direction, north, south, east, west, up, down, the person is not allowed to move away. For example, if a person is confined in a 4-wall room and the room is locked, then it will be considered to be a commission of a wrongful confinement. Similarly, here the restraint may not be a direct physical restraint. For example, the door may be open. So 3 walls of the room are closed, the door is open, but a gunman is standing therein. And it has been instructed in front of this person who has been confined that if he tries to move out, just shot at him. Then this fear of moving out of the room, even with an open space, that is a door, is not possible for the person because there is a threat that if I want to proceed out of this particular doorway, then I would be shot by the gunman. Similarly, we find cases whereby the court decided that if a person is using any other type of things which will create fear in the mind of the individuals. For example, putting a dog standard therein so that if you move out, the dog may bite you. So these also amounts to wrongful confinement. Here, wrongful confinement amounts to an act whereby the person who is confining the other individual does not have right to confine. For example, if a person is having a right to confine somebody, then it will not amount to wrongful confinement, for example, by following course of law. A police officer who is confining a person under offense is not a wrongful confinement. Similarly, a person who has been caught in stealing or any other unlawful activity and the person had been confined by individuals of the society or the building or flats where those persons were found to be stealing, then it is not wrongful confinement, because there is a chances that the person, if not confined, he will run away from the machineries which had been meant for protecting of the individuals. Section 342 provides punishment for wrongful confinement, and it says that the punishment may be up to 1 year's imprisonment and a fine up to 1,000 rupees, or both can be inflicted upon the individual who found guilty for confining a person wrongfully. So this offense is categorized as an offense which is compoundable offense. That is, the person who is confined, the person may compound the offense. That is, and mutually the person can let off the person who has confined the individual. Next section that is deals with next concept is the concept of criminal force. Criminal force is an extension of the section 349 of the Indian Penal Code, which deals with the concept of force. Force means an act by which a motion of the person is affected. So any act by which a motion of the person is affected, it is said to be using of force. For example, a person is standing and another person is pushing that person, so the motion is affected of the individual, it amounts to a force. Similarly, a person is sitting in a chariot, and if somebody lashes at the horses and the horse is moving, it amounts to movement of the person by use of those lashes. Section 350 or IPC deals with the concept of criminal force. A criminal force is the extension of concept of force. Force means when the motion of a person is affected by an act of the individual. This motion of the person is affected, that is, if anybody pushes a person, then the person's original position is changed. Similarly, if any person is using any other animals or any other objects to change the motion of the person by using any lashes or hitting that person, it amounts to use of force. When this force is used in a sense for commission of an offense, then it amounts to criminal force. In case of criminal force as described under section 350 of the Indian Penal Code, it provided that if somebody intentionally uses any force upon the individual so that the person's has been aggravated, any offense is committed upon the person, then it amounts to use of criminal force. In cases of criminal forces, we can observe that an intentional use, that is against the mens rea, is important along with the actus reus. Intention must be there of the individual who is using this criminal force, as well as some act must be conducted by the individual to the person or aggrieved person so that the person is affected in a way. So any damage may be constituted to the person, and that's why it resulted in the use of criminal force. For example, if a person is sitting in a chariot and it is in a standby position, and subsequently a passerby comes and he throws a stone on the horses of the chariot, or makes a lashes on the horses that are tied to the chariot, and the horses moves. Subsequently, a motion will take place, and as resultant, a damage or an harm may cause to the individual who was sitting in the chariot. So it will be considered as an use of criminal force. Similarly, a dog is tied and a person uses that dog and so as to bark upon another passerby who is passing by, then it amounts to use of criminal force. If a person is found to be using criminal force to another individual, then punishment prescribed under Indian Penal Code under section 352 says that 3 months imprisonment or punishment up to rupees 500 can be inflicted upon the person, or both. So 3 months imprisonment or fine up to rupees 100, or both can be inflicted upon the person who has used criminal force in this regard. For violation or commission of criminal force, section 352 of Indian Penal Code prescribes punishment. Punishment is up to 3 years imprisonment or fine up to rupees 500 rupees. Next, we are going to discuss about the concept of assault. Assault is an aggravated form of criminal force. When this criminal force is used upon individual in order to cause certain harms, and this force is used intentionally, then a criminal force will result into assault. In case of assault, any gestures or preparation must be made by the individual. That is, any overt act that is in the form of actus reus must be made by the individual so as to towards another person. This gesture or preparation should be must made towards another person so as to make some intentional harm to the other person. And as a resultant of this gesture, the person to whom it is made must have an assumption that certain harm will cause to him or her. So, intention as well as an overact by the persons is required, and at the same time, the other person to whom it is made must have an presumption or must have an thought in the mind that I am going to be harmed. For example, in this regard, we can give an example. If a dog is tied up with an individual and another person is sitting therein, a person started to untie the dog and say that I am going to leave this dog upon you, and you will know that how it will be upon you. So it is a cause of assault upon the individual. Similarly, a person, if moving a feast in such a direction, in such a way that another person sitting thereby may derive a fear that this lash or this fist he will hit with me, and then it will also amount to cause of assault. In many of the cases, this assault and battery, they are interlinked. The next stage of assault is the battery, that is commission of an act whereby the person actually heated the person. So assault is in previous step of commission of an offense of battery. Punishment for assault, in case of assault, the punishment is provided up to 3 months imprisonment or fine up to rupees 500 or both. So it is a criminal offense whereby a person can compound the offense as well as. That is the person upon whom this assault is committed, the person can compound or leave of this offense. It is a non-cognizable offense and it's a bailable offense. Next concept is the concept of kidnapping. Very prominent concept which is very widely used in Indian circumstances, and kidnapping is discussed under section 359 of Indian Penal Code, whereby it says that there are 2 types of kidnapping under Indian Penal Code. Firstly, kidnapping from India, and secondly, kidnapping from lawful guardian. Kidnapping from India means whenever a person is compelled to move in a way that the person is moved out of the territory of India, it is called kidnapping from India. Kidnapping from lawful guardian, it means a person is taken away from guardianship, taken away from the guardianship. Kidnapping from lawful guardianship means a guardian must be there and a person is taken away from such guardian's custody. In order to make a kidnapping an offense, there are certain essentialities provided under Indian Penal Code, and it says that the age of the person who had been taken away, this is very material in this regard. In this regard, the Indian Penal Code is very much clear that for kidnapping, for a subject matter to be kidnapped or a person to be kidnapped, the age of the person must be below 18 years of age if the person is a female, or 16 years of age if the person is a male. So they are under the lawful guardianship of some authority. Here lawful guardianship means any person who is maybe a natural guardian or entrusted guardian, or maybe a caretaker whom certain guardianship is allocated in therein, then it will amount to kidnapping. For example, kidnapping, we can say that if a boy is going to school with the daily helper of the family, this daily helper will be considered to be a lawful guardian. So in case of kidnapping, if the boy is taken up by somebody intentionally from that person without the consent of the lawful guardian, that it amounts to kidnapping. Similarly, there may be instances that if a small boy or a girl below 18 years of age or 16 years of age, a male boy, is within the compound of the house. In such cases, there is no person expressly who is looking after the person. But the compound of the house or the arena of the house may be considered to be a area where the lawful guardian is having authority, or it may be even the streets where the person is residing. So indirectly there is a guardianship or lawful guardian is there. So if somebody is taken away through enticing, so enticing is a word which is prescribed under Indian Penal Code. It means that whenever you lure away a person by saying something, for example, I will offer you toffee if you proceed with me, let's go for have some ice cream, or any other deceitful promises that has been made to the individuals. For example, promises of getting married, which is very common offenses in India, where the girls are lured away by the individuals who are below 18 years of age, that is the age of the girls. They are lured away that I will marry you, or somebody, I will get you married with somebody whom she may like. So it may amount to an offense of kidnapping, because the consent of lawful guardian is essential in case the age of the girl is below 18 years of age. Similarly, if the age of boy in this regard is below 16 years of age. For cases of kidnapping, there are prescribed punishment provided by Indian Penal Code. This punishment may be prescribed, it is prescribed that it is up to 7 years of imprisonment and fine or both. So a person who is held responsible for conduct of an offense relating to kidnapping under section 363 of the Indian Penal Code, it provides that the person will be punished with 7 years of imprisonment or fine or with both in this regard. Next concept is the concept of abduction. Abduction is an next stage of kidnapping, or we can say that in a case of abduction, the person who is the subject matter, they are the major, they are not the minors. That is, this age limitation clause below 18 years for girls and below 16 years for male is not there in abduction. It may be committed to a person who is a major. In case of abduction, a person is compelled to move from one place to another. This compulsion may be by use of force or by deceitful means. Deceitful means, for example, by force means you will be put under pressure that you have to move from one place to another place. Deceitful means when deceit is applied. Somebody says that, oh, a member of your family got hurt in an accident, come with me, we have to go to the hospital, and subsequently they take away the person from one place to another place. So moving of person from one place to another place, that is intentionally or intentionally by deceitful means or by force, amounts to abduction of the individual. The essential element for abduction is compulsion. So there must be compulsion made to the person either by force or by deceitful means, then an offense of abduction is committed. Punishment for offense of abduction, there is no specific prescribed punishment for abduction because there are various types of abduction that may take place, and depending upon the type of abduction that has been committed, that is the purpose for abduction, the quantum of sentences changes. For example, if the abduction is done for the purpose of marriage or throwing the person into slavery, throwing the person into prostitution, that is a flesh trade, or taking away a person for doing certain mining work. So depending upon what type of activity the person has been abducted by, what is the reason behind abduction of that person, the quantum of punishment is prescribed by the court in this regard. Next concept is the concept of slavery and forced labor. The concept of slavery is a stage whereby the individual persons lost all the rights that are enjoyed by the person. Every individual we know have got rights. We have got fundamental rights, we have got human rights, we have got legal rights. So slave is a person whose all the rights had been taken away by another individual. A slave is treated like an object. So just like an ownership is entrusted upon individuals over an object, if we are having a vehicle, if we are having a certain movable things and we have ownership over them, that we can exclusively decide that what to do with those things. The same thing is considered in case of slavery. A person as an individual human being will not be treated as, and he will be treated as an object. So all the rights of ownership will be exercised upon the person who is the owner of this slave. In India, the slavery is abolished long ago, but still we found in many of the cases this system is going on in the society, and that's why the Indian Penal Code has made a provision for slavery as an offense. Forced labor is another activity. Generally, it is related to slavery. In cases of forced labor, the persons who are the subject matter of forced labor, they went into certain activities whereby they willfully not want to do the activities. It is most commonly seen observed in the cases of mine working. In mines, and people are not ready to work because of the circumstances and health effect of these activities which are conducted in the mines. So we find that the people are forcefully indulged in such type of activities. In forced labor, extension of forced labor is a bonded labor, where the persons are taken away for doing certain acts and all the rights they are not exercising the rights. So both forced labor as well as slavery, both are prohibited under Indian Penal Code, and they are considered to be an offense in this regard. Punishment of slavery. Section 371 provide punishments for slavery, and it says that whoever indulged in the making people slave or habitually involved in the process of slavery, the person will be imprisoned for life. So life imprisonment is there for a person who are engaged in this offense of making slaves. They are habitually indulged in such making activities where they are making slaves, and they are maybe selling off these individuals to others, or such type of activities are conducted. Or imprisonment up to 10 years is provided for persons who are held responsible for doing proceeding with the activities of slavery. Punishment for forced labor. In case of forced labor, Section 374 of Indian Penal Code prescribes punishment for forced labor. Punishment of forced labor prescribed is simple or rigorous imprisonment up to 1 year, or with fine, or with both. The person who is found responsible for doing an activity which is promoting forced labor system, person will be punished with an rigorous imprisonment of 1 year, or with fine. Along this, all these offences which are committed by the individuals, and under Indian Penal Code, there are certain things which are necessary to understand in this regard. These things are offences categorized into cognizable offence, non-cognizable offences. A cognizable offence is an offence whereby a person need to get arrested within prior sanction of this court. So we can conclude that in offences against the human body, there are various aspects which are very important, and we have to take care of these. That the offences may be a cognizable offence, may be non-cognizable offence. A cognizable offence is an offence whereby a police officer can arrest one individual without a warrant. So generally these offences are grievous offences, the high category of offences where arrest can be made by the police officer and don't require a warrant. Non-cognizable offences are those offences where a warrant is required by the police officer for making an arrest. So generally the offences are in these categories may be compoundable offences. For example, those offences where the party or the aggrieved party may leave the person for commission of the offence, that is, a compromise is possible between the party. So cognizable, non-cognizable, this categorization is made of the offences depending upon the intensity or gravity of the offence that has been committed. Secondly, the other aspect that is looked upon is the bailable and non-bailable category. Bailable offences are those offences whereby a bail can be granted by the police officer who has arrested the individuals. So a person when arrested or being found guilty, not found guilty, the person is arrested by a police officer, the police officer itself may provide bail upon a bond. In case of non-bailable offence, the person can be only given by a prescribed magistrate or judicial authority who has been appointed for the purpose. So a person must be produced in front of the court, or the matter must be brought in front of the court, and then court will provide a warrant in a bail to the individual in this regard. And thirdly, the concept of compoundable and non-compoundable. Compoundable offences are considered to be petty offences where the party who had been affected, they can give away the person, they can leave the person for commission of the offence, whereas non-compoundable offences are the grievous offences where the person cannot left out the offence and there cannot be a compromise. The entire criminal law is based upon the fact that it is the responsibility of the state to take care of the rights of the individual. So the criminal law says that when offence is committed, this offence are the subjects to whom the offence is committed, though they are individual, their rights are affected, but it is considered that the offence is committed against the state. So that's why these steps are initiated, court is there, then this level defining of different types of offences are there. Depending upon the gravity of the offence, the punishments are prescribed. So the offences under human body, which are conducted under human body, here we have discussed on some of the offences conducted under human body. These offences are categorized basing upon this intensity of the crime, and this intensity of the crime will determine that what is the level of punishment that will be prescribed therein. In most of the cases, we find that the punishment which is prescribed is up to 7 years, up to 10 years imprisonment, or fine up to 1,000 rupees, or both. So this power is entrusted to the court to determine by looking at the gravity of the offence and looking at the circumstances in which the offence is committed by the individual. So depending upon the circumstances, the court will determine that what is the maximum punishment limit is provided. Up to this, they may be punished. So lower punishment, less than that, can be provided depending upon the acts and conducts of the individuals in this regard. So this is the conduct relating to this lecture relating to an offence commissioned against a human body, and hopefully this lecture is going to be beneficial for you individuals. Thank you very much.